So, thank you all for sticking with us into the afternoon. I'm sure the drinks at the end are encouraging in that respect, but delighted to be here again, joined by Matthew Kimber from the Law Commission, Noah Axler from Injective Labs, Mike Carter from FTI, and Mike Malarkey from Grant Thornton. In the ideal sort of decentralized world, Noah, I was wondering whether you could talk about how that approach might differ, or you might look at different things when it comes to dealing with decentralized exchanges and platforms.
Yeah, well, I think in the FTX case, you know, I would say you're running what's essentially a TradFi business, a centralized exchange. You've got to have your ducks lined up. I mean, it's a well-known path how to get processes in place that sort of run centralized TradFi exchanges. FTX is much more like that than it is like a true crypto native protocol, or was like that, much more than a true crypto native protocol. So in the DeFi space, you know, I think the analog is, first of all, the technology. Is your technology proposition sound? Has it been audited? Has it been tested? And of course, you know, I think in today's world, you know, and comparing it to 4 years ago, even in the DeFi space, I think if you're going to launch a protocol, you've got to have a clear game plan for how do you view decentralization, disintermediation. I know a subject near to Matt's heart. And, you know, that's both, I think, structural and legal. And so I think, to echo Mike, certainly talk to your lawyers. And usually you're talking about a development entity, right, that's going to set sail on launching a protocol. So I think there are some analogs, but I think in the decentralized world, you're really talking about making sure your code is sound and that it's providing value.
Yeah, totally.
Thought there'd be a Titanic joke in there. Well, this is not being the week of the Titanic this week. But this is being proactive and realizing that the compliance folks and the people who are the sales prevention department, if you will, are the folks that typically get left behind. And when things are moving so fast that some things just don't get overlooked going forward. I mean, to Mike's point, that's simple sometimes.
And it is tough, right? So when people who are much smarter than I am are building these, you know, what could be amazing products out there, their first inclination is not, all right, what's everything I need to do to comply with the laws? They're focused on the product, right? And, you know, you could make some arguments in the early 2010s, you know, when crypto is first emerging. Okay, that's a sort of a reasonable approach. People know better and have known better for a while, frankly.
Yeah, I think that's the key point. If I was to go back to your question back in time, it is, for a company that was so focused on saying it had the best product in the industry, and it was the best product, you have to actually focus on your product, and you have to actually think what you're doing. You're acting as a centralized intermediary, effectively as a custodian for people's stuff, or people's money, or however you want to think about these things. So you should structure that product as best you can. And what we saw for intermediaries and custodians over the last 4 or 5 years, it's happening a bit better now, but what we saw was they said, on insolvency, we don't really know what happens, but that was not really an insolvency point. It was more like, yeah, you've not said what happens. You've not said, is this a contractual deposit relationship, or is it a trust relationship? And you've had these arguments. We've had a case that came out this week in Hong Kong, Gatecoin, about whether it's a trust or whether it wasn't. We had Coin back in 2018 in Singapore, we had Roscoe and Cryptopia, and we're having FTX now in Celsius. That was their product, and they weren't even specific on what they were offering. So yes, they had a good matching engine, yes, they had a good liquidation engine, but their core product, looking after people's stuff, wasn't correctly right, and they didn't tell the customers what they were providing. So that is, I think, a lesson that it's not just tech, it's also your product as a whole that you have to focus on.
Yeah, I would totally agree with all of what has just been said. And obviously now we've sort of piqued the interests of the regulators who are increasingly looking at in this space. I think actually today EU Parliament has voted through MiCA. So I think, or MiCA or MiCA, however you want to call it. And I think that will, I think the the timetable for that is we're looking at sort of 2024, but also there was the travel rule regulation vote today, which deals with money laundering in crypto. And so you're seeing regulators trying to sort of fill the gaps, query whether they're doing it in the right or the wrong way. But that's a question that I'd like to ask to the panel. What do we need regulation actually to ensure minimum standards of compliance in this space?
I think what the regulator will need, we haven't thought of yet. I think we'll need something here. We're trying to craft regulation here that just doesn't really fit for what we're doing, using the examples of the last panel. I think we haven't thought of it yet. I think dating something back to our savings and loan crisis in the US, having an RTC as a bailout mechanism, I think having a SIPC or something like that, where we've got some backstop to transactions when things do go south. I just don't think we haven't thought of it yet. I think that the framework we have right now is not working, and it's stifling innovation. It's not a speed bump, it's a roadblock. And that's something that I don't think the industry will command respect for. So
and to that framework, Mike, there's a core difference between the rules are unclear, and whatever rule you're talking about, I'm not going to go overly specific here. The rules are unclear, we don't know how to comply. And then there are rules, and we understand, we fundamentally understand them, and across all types of financial institutions or other obligated entities, those rules and frameworks are really similar. So again, I go back to, we don't know what we're doing. Okay, that's true in some aspects of regulation and compliance. But to Mike's point, that's where we do need regulators to come in and provide clarity where it does not exist.
And failure is not a bad thing. I'm a .com guy back. We had a company called Blackboard 25 years ago, and how many .coms are now not here anymore where we didn't cry we needed more regulation. Sometimes that works, and sometimes the invisible hand works sometimes. When there's not some type of fraud or some other type of issue around that, but maybe we don't need to react every time something goes south.
Yeah. And Noah, from the US perspective, obviously it's quite a different approach. I mean, people are calling it regulation by enforcement, and looking at how, particularly the challenges around, regulating the decentralized space and whether that should in fact be regulated, because it sort of goes against the philosophy of blockchain in the first place, and that it should be decentralized. You are democratizing ownership. What would you say to that?
Yeah, I think the decentralized space has evolved to the point where I think most participants in it realize there's going to be some degree of regulation. I think the battle line is, it goes back to the technology piece, and it's sort of philosophical, but it obviously bleeds into the legal, which is, if this is a truly innovative technology, which a lot of people, including myself, believe it is, and you even see TradFi players adopting it and moving toward adoption. So there's a lot of signals that the software itself, the tech itself, is a value add. So if that's the case, I think the DeFi perspective would be, let's regulate this in a way which allows the technology to develop rather than stifles it. Even within the SEC, one of the commissioners has several times proposed a safe harbor that sort of allows protocols to launch using, I think, what's essentially a disclosure regime. Like, there's going to be some disclosure about what the protocol does, and then you have 2 or 3 years to register. So I think something like that is, much more appealing to the DeFi space than what we have now, obviously, in the US, which is very difficult to navigate, and leaves you, as a lawyer, with some very difficult choices. To some degree, there's always been an amount of regulation by enforcement in every industry, but I think fairly in DeFi, we feel that it's time to maybe get some coherence in the message.
Yeah, and coming back over to this side of the Atlantic, Matthew, I know you've been involved in some really, I'm going to fly the UK flag here, some really groundbreaking consultations and responses and legal statements that really have helped to shape the law and how it's been applied in a number of court cases now. I was wondering whether you could speak to what's been happening in the UK.
Yeah, sure. So, sorry. I think it's an interesting point to think about regulation by enforcement. I guess in the US, that's how it's been characterized, although there are lots of other developments. And to think about MiCA, which started off basically as a let's kill Libra type regulation, but through its consultation process and through a lot of work from lots of people in the market and across the jurisdictions, it's actually formed into something that people broadly in the industry think could potentially be positive, if that's about as kind of as keen as I can get on it. What we've done in the UK is a little bit different, is much slower. We've taken a kind of a lay the foundations of private law approach first, so let those questions of trust, contract, all be answered as a matter of private law, and then let regulation build on top of that when there is certainty. That necessarily takes time, but what we've done at the Law Commission is to take a very consultative process, because we recognise that lawyers, regulators have to learn from industry participants and have to recognise that there's new technology and won't know how that technology works. Consult with people, say things that we think are right, get told they're wrong, and then actually listen to that feedback and change what you were going to say, rather than just hear the feedback and not change what you were going to say. So we've done consultations on smart contracts, we've done it on digital assets, DAOs, we're doing one on conflicts of laws, and we've also done one on electronic trade documents. HMT has done consultations, Treasury have done consultations, Revenue and Customs have done consultations. It's been very consultative, but we're hopefully going to get to a MiCA, I guess we're going to get to a MiCA-like process, but not quite the same. So I think that approach is helpful, but it necessarily takes a long time.
Yeah, I wonder if we'll end up somewhere which is like MiCA light rather than exactly MiCA-like, to remain competitive. We'll see. But I think there's lots of really important and interesting guidance coming in. And I was actually involved in the UK jurisdictional task force statement on digital securities, which was looking at how the existing English law can apply to the issuance and transferability of digital securities, and whether it can already support what is being done there. And the answer is generally a positive yes. So I was involved with that with my colleague Louisa Watt, who was on the last panel. But Matthew, I wonder if I could pose this question to you, because obviously you've been receiving responses from consultations, digesting that, and then coming up with papers. How important is it, do you think, that crypto natives and people that are really operating in the space are engaging with that? Because I know as law firms, we do engage with a lot of that, and we do have oversight as to what our clients are doing in this space, but I think really there's so much nuance in this market that my view that it is really important to help shape policy guidance law in this area.
Yeah, so I think I personally think it's fundamental, because there is still a lot of the market, not necessarily people in this room, but in the wider market, and given that the crypto market is reasonably small compared to the traditional finance markets, that just think this is really just intermediated largely it's the same type of kind of intangible assets as other assets in the normal financial sense, and particularly when you start talking about digital securities, so equity securities and debt securities, they just think they look like traditional dematerialized securities that work in CREST-type systems. Now, that probably isn't true from my perspective, but it does take feedback from people who are actually working in the market that structure things in a different way and take benefit and use of the different technology and the different way, the structuring options that you can take from that technology to say that to people. Otherwise, you just have traditional people who've worked for ages on Geneva Securities Convention, intermediate securities laws, who just say, well, you can kind of do this, we've already done it before. So it's really important, and lots of your legal teams will be able to feed back into these types of processes, and it's really welcome and needed.
And do you think that sort of same approach is being taken on the other side of the pond? Is there the opportunity and the openness? Obviously, you were talking about being able to sort of test certain things. Is that open relationship there to be able to have a constructive conversation with the regulators as to how this should be dealt with going forward?
Well, I think there's certainly been dialogue between the DeFi space and regulators, including even the SEC, at least on a sort of policy discussion level. The statements that you can come in and register as a crypto protocol in the US, I think a lot of us wouldn't agree with that as being a viable option. I think what we're seeing in the U.S. now, and again, just personal opinion, is there are people at all of these agencies who understand crypto pretty well. I think there's just sort of a battle of, is this an industry we really want to encourage or heavily discourage? I think, again, my personal view is, I think U.S. regulators realize crypto's here to stay, and they're just trying to, obviously there's partisan divide on this, but they're just trying to come to sort of an agreement on what it should look like.
Yeah, and obviously, the differences in approaches between different jurisdictions have created a bit of opportunity or maybe not an opportunity for jurisdictional arbitrage, depending on whether you think it's a good or a bad thing. I was wondering, if I start at the other end of the panel, what are your views on the ability to arbitrage between regulatory regimes?
You probably got more experience there. I think it's a bad thing. I think to have jurisdiction shopping or opinion shopping in my accounting parlance, I think that's typically a bad thing for the industry, where there's an unclear set of rules that you can go out and find what's best for you in one particular transaction or solution. I think just isn't good for the industry. I'd rather have a consistent set that is, whether it's US, UK, pick a jurisdiction that people can abide by, know the rules, and work within that. But having multiple jurisdictions, I don't think that helps anybody, and certainly doesn't help growth.
It's a little interesting. Just informationally, I just came from a notable exchange that has been discussed today. So it's appropriate in some ways, and specifically from a products and services standpoint. So some jurisdictions allow certain types of products and services, and they're a little more open to it, as long as you have a reasonable, defensible product listing process. And some are not. And those are really can be more business decisions, not, hey, we want to go to a place where we're going to be less compliant. In fact, I think it's a little counterintuitive where you'd have small banks going to high-risk anti-money laundering jurisdictions / islands back in the day. Well, now crypto and blockchain projects still sort of rely on traditional on TradFi systems and those banking and payments relationships. So if you're making a choice to go to a high-risk, low-regulatory jurisdiction, that's probably going to come up in your partnerships and your banking relationships, and ultimately somebody's going to see whether or not your compliance programs are defensible, being executed in earnest, appropriately staffed, and appropriately resourced. There's nothing inherently wrong with it. Are there going to be outlier cases where, yes, people are jurisdiction shopping because they're getting pressure from one jurisdiction and they don't want to deal with a certain regulator? Sure, that absolutely exists. But again, being a little nascent globally, specifically with how these products are viewed, yeah, I mean, it makes sense if you want to service different sets of clients with different products. It's appropriate as long as you're doing the core fundamentals correctly.
Noah, Matthew, anything to add to that?
I mean, I generally agree with that. I mean, I think regulatory arbitrage is somewhat inevitable. Understand the drive for it. I'll turn it over to Matt in a minute, but one of the interesting, in the U.S., let's just take it at a really granular level. If things continue to proceed as they are in the U.S., on the other side of the coin, right, you have, and this was discussed on some earlier panels, you're starting to see civil lawsuits, class actions against protocols and the investors behind them. Class action plaintiffs' lawyers forum shop for where they think the best and most favorable judges are for their cases. The SEC doesn't do that as much because they have some selected jurisdictions and they know they're the home team in every jurisdiction. But so you'll even have, if we continue on our current path in the U.S., a lot of divergent common law decisions coming out that are going to further complicate the field. It's not just going to be the regulators making the law. It'll be judges ruling on private civil actions.
But where there's, and sorry to jump in here, but where there's clarity, and so you can equate clarity with more regulation, we're actually seeing those jurisdictions gain steam. I mean, I've been dealing with the regulators in Bermuda for the better part of the last 3 years. They have a very clear framework, clear standards, high standards, frankly, but you know what they are and you meet them or you don't. And Dubai is heading that way, and Europe's heading this way, and the UK is heading that way. And businesses are interested in that because uncertainty costs a lot more money than certainty with high standards.
Yeah, I think Noah's point was really good as well, that right now the focus on kind of arbitrage is reg arbitrage because there's so much difference between the regulatory regimes. Some places, I guess like the UK, there aren't really that much of a regulatory regime as an MLR regime, AML, MLR. But once the regulatory regimes get more consistent, then you'll have other arbitrage, legal arbitrage, bankruptcy we talked about before on the previous panel. Where's it best to bring your bankruptcy? Do you bring it in Bermuda or do you try and get it into the US? I was an ex-bankruptcy lawyer, so I would obviously say that the UK scheme of arrangements and plans are a great place to do bankruptcy. So while we do talk about Reg Arb now, and it's on the front of people who are in the market's mind, that Arb is just not limited to regulation. It's kind of global as well, and legal structuring, contract trust, all those kind of options as well. What law do you choose for your contracts? It's all part of the decision making for companies when they're building their products and their business.
Yeah, and just picking up on that point that it's not just about regulatory arbitrage, it is also going to be about, jurisdictional arbitrage in the courts. Obviously we spoke earlier about the tulip trading case, and I think it's worth mentioning that while the Court of Appeal there didn't, found that there was a serious issue to be tried, the leading judge who delivered the judgment said that actually he cautioned that it would involve a significant development in common law fiduciary duties in order to get over that threshold. So we're not quite there yet, and if there's any developers in the room, that's probably good news to you. But we'll wait to see what happens with that. I think that is set down to go to trial in 2024, and it will be subject to the full trial process, including factual evidence, expert evidence. So we'll see how that develops. But I was wondering, it seems to me that there is perhaps a bit of a tension between decentralization and promoting compliance. I know, Matthew, you have some views on this.
Yeah, well, we've seen it in the recent Jump Oasis case, where we saw a notionally decentralized product, the Oasis app. The Jump guys obviously wanted their 320 million back, and so they were kind of incentivized to find an update or a hack for the Oasis product. Oasis said, cool, what do you want us to do about it? We're not going to do anything without a court order. And then the court, I think the English court actually gave an order on the basis that there might be a good arguable case for that in the New York court, which is ongoing. And then Oasis complied with that order effectively to hack the hacker and put some assets, I think in kind of some kind of escrow account, which really demonstrates that so when you're a centralized product, you can do that, and a court tells you to do it, you can do it. If you're a truly decentralized product, you simply say, we can't do it, there's nothing that we can do. So I think that case just draws a very stark distinction between the level of decentralization that you need to get to, and when you're creating a decentralized product, I think what you have to think about is, okay, for all intents and purposes, this is decentralized. If I get a court order telling me to do something, what am I going to do? Am I going to say no and be in breach of a court order, or is my response, I can't do that because of the nature of my product being decentralized? And I think that's a really important thing to think about. You have to think about what a court's going to do and what you're going to do when you get that court order on your doorstep.
And I think that is why it's important to flush these issues out in trial and in a contested trial, so that you hear both sides, because we had a chat about this last night, but I don't know if it's even technically possible for the developers in the tulip trading case, which is, it's the developers of the various Bitcoin networks, whether it is even possible to reroute the crypto back to the claimant in that case. My understanding, and it's fairly limited, is that this would involve sort of forking the network. And where do you draw the line there? You gave a really interesting analogy yesterday, which was very nostalgic to me about Fantasia.
Yeah, so I think in the tulip trading case, the control point will come up in a different way, but a very interesting way. It will come up in the context of whether or not the developers owe a fiduciary duty to users of the network and potential certain users. And one of the arguments at trial was the level of control that developers exercise over the network, but also over the assets. And it's a bit complicated to go into in 12 minutes, but then you also have to think about, even if that argument succeeds, what is the consequence of the developers? What is the remedy that can be given? And is a developer just going to deploy, is a Bitcoin core dev going to deploy a patch to the network, and then you have effectively, it's probably going to be a hard fork, because you're probably not going to be able to achieve that patch with a soft fork because no one's going to agree to giving Craig Wright 3 billion Bitcoin back without a hard fork. So then you have a hard fork, but then what if you have another case, and another case saying, well, now based on that case, you owe me a fiduciary duty, you owe me a fiduciary duty, then the developers have to deploy another fork and another fork. And we know that these are network-based systems which rely on social participation. So each time you're diluting the effects of those networks and making those networks less effective, almost like what's happened with Bitcoin ABC, Bitcoin Cash, etc. already. So it's not just about the level of control, it's about how that control necessarily being decentralized within these networks works, and what can you do about that even if there is some control. So it's going to be a really interesting case, but it's a good case as well, because it is the most probably decentralized coin in existence that's kind of on trial. And then you have Bitcoin ABC and Bitcoin Cash as well, which are clearly less decentralized in some ways. So really interesting to see.
Yeah, and I think it's, where do you draw the line? You potentially open the floodgates. I mean, he says that he's lost the equivalent of £3 billion in Bitcoin. If someone's lost, £1,000 worth of Bitcoin, that's obviously still a large amount to any individual, but, where do you draw the line? Is it fair to say, because he's lost such a significant sum, we should do this for him and not others? And then, how can you favour one user in the network over other users of the network? I don't know if you've got any views on this, Noah.
Well, it's these cases raise an interesting Pandora's box in the context of some of the US developments we've been talking about. Like, what if a protocol gets a court order, like in the jump case, and says, we're just not going to respond, the community says we're not going to respond to it. Presumably then you have some sort of result like in Uki DAO, where, although that's the CFTC, you can imagine private plaintiffs seeking to get a judgment against the DAO itself and maybe its participants as general partners. And then the problem becomes, well, probably some of the participants in the DAO are identifiable, right? They're not anonymous, and others are. So you sort of get penalized for being identifiable in that situation. It just sort of turtles all the way down, an endless stream of questions and potential liability that sort of flows out. And then, to Matt's point, okay, if a protocol responds, yeah, we can comply with the court order, it's essentially an admission. We're not as decentralized as maybe we want to be, or we've told people we are, and that can lead to other unpleasant consequences.
And maybe that's a downstream aspect of these products that eventually gets built in, and it's a little tricky and hyper-technical, but Amanda from Women in Crypto mentioned it earlier. If you've got these sort of escape hatches where if we've got defined legal orders, court orders, law enforcement requests, and certainly it's complicated defining those, especially globally, on what's valid and not valid. Then you're creating the smart contracts if-then statements. If this meets this criteria, then potentially yes, the community will respond. And maybe regulators look for those things in the future. If you're offering it as a quote unquote licensed product.
The test is going to be either you can't do or won't do. And if you're not doing something, you make an active decision to ignore certain regs or things that make sense, that's where I think the line will get drawn versus, can't do, and we don't have the ability to do it, but if we're actively not doing it, that'll be one test built in there, I think, at some point.
Yeah.
Getting back to compliance, yeah.
And we'll see how tulip trading plays out, but the way that Burrs, in his judgment, expressed the hurdles that would have to be got over by the claimants to make out their case is really interesting, because he basically sets out 6 or 7 hurdles, and he also says you're going to have to do this for all the different softwares, so all the different forks of Bitcoin that you've got before us, they're all different, which is a really interesting point that he's made in the Court of Appeal. Now, since the Hinman speech, there's been a lot of kind of people saying, well, a lot of people relied on sufficient decentralization for a long time, and that kind of didn't work out that well in the US. But there's been this concept of sufficient decentralization. I don't know if it will necessarily happen or not. It depends how the case plays out. But you could imagine that over the course of a high court judgment is probably going to get appealed, and a Court of Appeal judgment, and probably again a Supreme Court judgment, you're going to get a big stream of English case where it's been argued every time, and you come out of that case at the end maybe with something that looks like a test for sufficient decentralization at law under English law. Now, no one's really going to be able to achieve that probably in a regulatory sense, because it's really difficult. I've thought about it, but it's actually really difficult. But if you get it at law for the purposes of fiduciary duties, it's a really interesting legal precedent to have for other types of argument later on, like we can't do this because we're sufficiently decentralized, etc., like, to your point. So that'll be one to watch, although don't hold out that much hope, because it's going to take like a 6-year process to get through the courts, or maybe 3, 4. But it's something to bear in mind for the future.
Yeah, for sure. And are there any areas, this may be a controversial question, but are there, and I think people would have different views depending on whether you're a lawyer or in compliance, or you're a builder or developer, are there any areas in this space that you think should not be subject to regulation and actually is much better done through self-regulation, self-compliance? Mike?
I'd like to be a CCO again someday, so I'm not going to say things should not be regulated, so I'll abstain there.
I think the market works, and again, the earlier theme that I think in your sport analogy, you have enforcers. I'm a hockey fan. You have enforcers. It's sort of, you go after one guy, we go after you. And I think that the market will go after people that are non-compliant, and sort of, I think, move that away from the government, realizing that the entire industry, having the government involved doing things like that, just does not make sense. And I don't want the government arguing with me about waxed or unwaxed dental floss. I want to fix the problem. And I think if we're making active steps to be compliant, to act like a good corporate citizen, to Mike's point, that's where the industry needs to be. How we do that, I'd like to see the market work and have enforcement mechanisms to do that with behind the scenes activity between players. But I think the more that things go south, that just doesn't help anybody. So I like the idea of the self-policing, how we do that.
I mean, there are data privacy concerns with the obvious traceability of blockchain, and what the government shouldn't be able to see with regards to private citizens' transactions. So that sort of falls in that gray area of, I don't even know if I would call that this shouldn't be regulated. I actually think that should be regulated as well, and what's able to be tracked, traced, and seen without appropriate court supervision.
You're so subtle, Jess, to try to get us to say there's something that shouldn't be regulated. I guess it'd be nice if there was a bright line of what, let's say in DeFi, constitutes software development versus running a protocol or running a platform. I mean, it'd be nice to see whatever's in the bucket of pure software development not be regulated, but there's so many issues around that in DeFi because you're talking about money that I don't know that we'll ever get that bright line.
I probably shouldn't say either, but I'm going to anyway. I think a really easy one is self-custody. So if you think about these assets, they were built such that you can self-custody assets or whatever you want to call them. And that is very different to securities or debts where you have a counterparty and you have a right or a claim against them enforceable by action in the courts. So I think that the ability to self-custody assets would have to, regulation around preventing that or adding backdoors into MetaMask or hardware wallets or whatever it might be so that other people can interfere with those assets. I think regulators ought to think very carefully about interfering with that because it's interfering effectively with personal property rights, albeit that they're intangible, and that is the fundamental core feature of these assets that makes them different and function differently from other types of assets. So that would probably be the area that I would say.
Yeah, that's a good point. I mean, and even the recent U.S. Treasury report on illicit finance and DeFi explicitly said, we're not seeking to regulate purely peer-to-peer transactions. And, that sort of speaks to the software issue too. Maybe there's a bright line there. Unfortunately, the report got a little bit confusing after that about what are purely peer-to-peer transactions. But yeah, I mean, if we had a clear test for that, it'd be very helpful.
And I was just wondering if anyone in the floor was brave enough to put their hand up and suggest what. I see Stephen Pally putting his hand up there.
I have a question. I guess one fundamental question is, does crypto make compliance impossible at a certain level?
No.
Are there certain things that you cannot, that are fundamentally in opposition to regulatory compliance?
I mean, my short answer on that is no. The slightly longer answer is, the lawyer answer and consulting answer is it depends, but it does enable some things. I'd always tell our banking partners, when we're going through our rigorous, due diligence, and not being funny there, very rigorous due diligence, I know more about my customers than you do. And that's true in many ways. And I think if you're doing all the right things, but you're potentially enabling digital identity. You are potentially enabling, once we figure out all the, I hate even throwing this term out, the proof of reserves, proof of assets, that gets thrown out a lot. And the way it gets used recently is kind of nonsense. But how do we figure out the auditability in where assets actually, quote unquote, live and who possesses them? And sort of what all that means for the auditability and safety of these products. So no, I mean, I don't think the two things are incompatible. Are there limitations? A really good example is if you're operating a central exchange, it is virtually impossible to block an inbound blockchain deposit once a wallet has been created. There are, at minimum, sanctions implications there, even if you have frozen a customer's account, offboarded him or her, and it does create challenges. But
it's allowing us to do things differently. 25 years ago, the argument was, hey, we have the internet now. Does the internet make compliance impossible? Same question 25 years ago. Now, we do things a little bit differently. We adapt to it, and it's just a means of doing something differently, and that will adjust accordingly.
Could I interject? The fintech industry, in terms of compliance, quite often would go for a compliance model of specialist regulatory hosting companies, which would act as sort of compliance incubators for fintech companies that were starting up and wanted to try new things, but would find the compliance piece quite difficult because it's not their area of specialism. Do you think that in crypto, when the regulation becomes clear and it becomes into the regulatory activities order and it becomes more like everything else in the UK, do you think there is a place in the market for regulatory hosting specialists to set up and just bring all these cryptos in as appointed representatives? Although bearing in mind that the appointed representatives regime features in the FCA business report for the year ahead, that they're going to look at it, and also the Treasury has said that the appointed representatives scheme has had lots of problems. Greensill abused it, for example. But it may be that there is a business opportunity there for specialist regulatory hosters to say to the crypto industry, once you do get some kind of fairly clear regulatory system, come on board and be our appointed representatives and we'll be your regulatory hosts.
are we talking about outsourcing compliance functions? Is that the
Well, it's the
summary?
regime that we have, which is called the Appointed Representatives Regime, which is under the Financial Services and Markets Act. And it has been where the individual firm does not have to become authorized and get direct authorization from the regulator, but they can have an arrangement and a contract with a regulated firm which acts as its principal. It's not actually an agency, it's through a contract arrangement. But this has been used. If you read the Treasury paper on appointed representatives, they have got a whole section on how fintech incubators have made great use of this system because it's easier for them to do when they're starting up. Because regulation and compliance is very, very expensive and difficult. Yeah. And that this might be a way forward once they do get the clarity with the new proposed, the Treasury consultation, when that finishes and they get some new regulation.
Thank you.
Yeah, I'll summarize. I think you can outsource compliance functions in that authority. You cannot outsource the responsibility to do it well.
Thank you very much. Wonderful panel again. It's a shame we don't have hours and hours for all of you.